All right, we're going live. So this is Chris Bayer with Castle Wealth Group, and we do these weekly wisdom webinars every Wednesday at 1 o'clock. And this is where we just take a moment to answer any legal, financial, or tax questions that come in. And it's not scripted or anything. We just cover whatever questions come in. And so if you do have a legal, financial, or tax question that you haven't already submitted, then feel free to put it in the Q&A and we'll go ahead and address it. And I like to always start with positive focus, just something positive that's happened over the last week or so. Personally, both my kids finally wrapped up their sports. So both of them were playing soccer. My son was playing flag football. My daughter, her soccer team, which I coached or was assistant coach, went undefeated this year. So that's the second time she's went undefeated. My son's soccer team, they came in second in the league, so that's pretty good. Flag football, that was a little bit of a struggle this year, but it's good to have all those activities done and actually have a free weekend again. So with that, I'm going to share my screen, and the first question that was submitted was asking, what are the difference between qualified and non-qualified accounts? So let me share my screen. And again, these presentations are not PowerPoints or anything like that. It's really on the fly, whatever questions people have. So let me share my screen. And really, qualified accounts, why they're called qualified accounts is because there's some type of tax qualification to them. Like anytime you have an account that has like letters or numbers in it, chances are it's a qualified account. And there's different types of qualified accounts. There's tax deferred accounts and tax-free accounts. Tax deferred accounts are going to be like your traditional 401k, your traditional IRA, traditional 403b, 457. These are accounts that you've never paid tax on. You never paid income tax on. So a lot of times they're from an employer that maybe you rolled over. The key thing with these is whenever you take money out of the accounts, you're going to pay income tax. Okay, because you never paid income tax on in the first place. And also a key with qualified accounts is they cannot be owned by a trust. You can name a trust as a beneficiary, which is one of the questions someone had. So with the IRA, you can name a trust as a beneficiary. The trust cannot be the owner of your IRA. The trust can be an owner of a beneficiary IRA. So if you inherit an IRA, that could be pointing to the trust. So the trust could be the owner for the benefit of child one. So if it is your IRA or your 401k, you have to be the owner. And then typically we would name spouse as a primary beneficiary and then trust as a contingent beneficiary. And then same with the Roth 401ks, Roth IRAs, 529s, health savings accounts. These are all money that's post-tax that grows tax-free. So again, there's some type of tax qualification with these. And again, because they're qualified accounts, the owner has to be an individual. It cannot be joint with a spouse. It cannot be owned by the trust. It has to be in the individual's name. And again, with these tax-free qualified accounts, typically, depending on the type of account, but typically it's spouse first, and then we would name trust as the beneficiary. Now, there's a big law change in 2019 called the Secure Act that said if a beneficiary other than a spouse, basically, inherits any qualified account, they have to take it out of that qualified account within 10 years. And so that means for the tax deferred accounts, they have to pay the taxes over 10 years. For the tax-free accounts, they don't have to pay any tax. They just have to take it out of the accounts. With all of these qualified accounts, one of the keys, and when we talk about funding a trust, one of the keys to understand is that the trust is not the owner. The trust can be a beneficiary of these accounts. And typically, depending on the situation, we'll name spouse first, and then trust is the contingent beneficiary. Now, if we're setting up an asset protection trust, if we're pulling money out of a traditional account, we'd have to pay the tax on it. If we're pulling the money out of like a Roth 401k or Roth IRA, there's no tax. So there's no tax consequence of pulling it out and putting it into a trust-owned account. Okay, so we have qualified accounts, and there's really two types: tax deferred and tax free. And then we have what's called non-qualified accounts. And basically that's everything else. Okay. So any other type of account, whether it's a checking account, savings account, brokerage account, typically is what we see, investment account, money market, high yield savings accounts, CDs at the banks. These are all non-qualified. The key things with these non-qualified accounts is that a trust can be the owner of these accounts. And it doesn't pay trust tax rates or anything depending on how the trust is set up. So if we set up an asset protection trust, we can move non-qualified accounts into the asset protection trust. I was having a call with a family yesterday, and they had a little bit in qualified 401k, a little bit in Roth 401k, and a lot in non-qualified brokerage account. And so we're talking about setting up the Castle Trust, the Asset Protection Trust, and we're talking about funding. And we talked about how a majority of their assets were non-qualified. So the brokerage account can go in there, their big high yield savings can go in there. What could not go in there is their traditional 401k. And we talked about maybe cashing that out because most people think taxes are going up in the future. And then also we talked about pulling the money from the Roth. And also the important thing, unless they change the laws, and President Biden has talked about that, is that anything non-qualified, when it goes to the next generation, it acts similar to tax-free, where they don't have to pay any taxes because of step up in basis. So really, from a tax perspective, the big thing that we need to watch out for is the qualified tax deferred accounts. The rest of it, whether it's tax-free qualified accounts or non-qualified accounts, that's all going to beneficiaries tax-free. And that's why a lot of our clients are looking at IRA or tax deferred exit strategies, trying to get money out of these pre-tax accounts just because they think taxes are going up in the future. So really, it's not super complicated if you deal with this on a regular basis. Qualified accounts are basically anything that has a tax qualification, whether it's tax deferred or tax free. And typically they're going to have some letters and numbers attached to it. So 401ks, IRAs, 529s, 457s, these are all qualified accounts. So hopefully that was helpful in terms of understanding the difference between qualified and non-qualified accounts. It's something that comes up all the time, so hopefully that is helpful. Okay. Now we're going to switch to the next question. And again, if you do have questions, feel free to put it into the Q&A. So let me just paste this question here. And all right, let me share my screen. All right, so here's a question. Brother and sister inherited and are tenants in common of a home. Brother later passed away. He was unmarried and no children, so his interest in the home went to sister. Is there any way sister can sell the home without needing to probate brother's estate? Sister inherited, brother passed away, he was unmarried, no children, and his interest in home went to sister. So here's the thing. There's two types of joint ownership. There's what's called tenancy in common, and then joint ownership with right of survivorship. I'm kind of spelling that wrong. Typically, it's a joint ownership with right of survivorship. So with tenants in common, what happens is when one person if they're joint and one person passes away, their share goes into their estate. With joint ownership with rights of survivorship, it goes to the survivor. So unfortunately, in this situation, if it was tenants in common and it didn't list joint ownership with right of survivorship, they're going to have to go through a probate. There's no other way around it. The way around it would be to go back in time and have a joint ownership with right of survivorship. But unless the deed specifically said joint ownership with right of survivorship, unless it's a married couple, they're going to assume it's tenants in common. So with tenants in common, that's going to go to, unfortunately, probate. All right, here's another question. Again, if you do have a legal, financial, or tax question, feel free to put it in the Q&A. I have a couple coming in. So if I have a Castle Trust and I want to get a CD with a good interest rate, do I open it under the trust name, not my name? I would say yes, depending on when you plan on using the money. So from a financial planning standpoint, I like to break things into like now, sooner, or later buckets. Like now would be 0 to 1 year. Like, are you going to spend the money, not reinvest the money, but spend the money within the next year? Soon, depending on your situation, might be years 1 through 10. later might be 10 plus. So if this CD is set up so that you're gonna use it to buy a car in 6 months, I would just keep it in your name. If it's something that you might not use or reinvest in the future, then I would name the trust as the owner. Because again, the Castle Trust, that provides asset protection trust or asset protection. You can get the money out of the trust anytime, but understand it provides asset protection. So if it's something that's going to fall into the soon bucket of money or the now bucket of money, then just have it in your name. But like if you're going to buy a car in 6 months or fix up the roof in 6 months. But if it's something that you just want it safe, figure out what you're going to do with it in 6 months or 9 months, then I would have the trust as the owner. And then just open up the CD in the name of the trust. And then once the CD matures, then you can invest in something else in the trust. All right, so answer that, and I had another question. This out of the way. Again, if you do have legal, financial, tax question, please put in the Q&A. Here we go. Oops. All right, so here's the question. Share my screen, give me a second. As we get less involved in day-to-day activities of the cabin, is there a formula for providing to those who wish to opt out of a share of the cabin? Yeah. So this is really a family dynamic question. But the scenario typically is we have this family cottage. It's been in the family for a number of years. Let's say there's 3 kids. How do you, and you want the cottage to stay available in the family? This is kind of a complicated, it really depends kind of answer. It depends on the family and what they're trying to accomplish. Because the issues you run into, it almost ends up being like a family business. Where, okay, once mom and dad pass away, now it goes to the 3 kids. And IRA Trust. And now it goes to the 3 kids, and the 3 kids might have differing views and goals and net worth. And so there's lots of questions that pop up. Some families take a very legal approach to this of drawing up like articles of organization to say, okay, if family doesn't contribute to like the cottage fund over a period of 3 years, they get knocked out of the cottage trust or cottage LLC. Some families have gone as far as to like talk about how they're going to work out the weekends and stuff like that. And then I have some families that say, you know what, once we pass away, we're just leaving it to the kids, and it's the kids' issue to figure out. So there's no perfect answer on this. There's no magic formula, unfortunately. It's kind of like setting up a business. Most of my clients, like mom and dad, they say, you know what, like, I don't want to pay for this. I don't want to worry about it. Let's let the kids figure it out. But some families do want to kind of create some rules or structure around it. I see some families when they pass away, they'll say the cottage is held in trust for the kids, and then they'll allocate like $50,000 or whatever to be used for cottage expenses. So that the other families don't have to chip in. Like, who's going to pay the property taxes? Well, what if one of the families doesn't pay the property taxes? Does their share then get reduced? So it's kind of tough. Like, you don't want to overcomplicate, overthink it, because the more complicated, the more legal fees you're going to pay to set everything up. And then also, you can't legally come up with every scenario. From doing this 20 years, we come up with a lot of the main ones, but there's always, with family dynamics, something pops up. So I don't really have a perfect answer other than big picture. You can look at it one of 2 ways: let the kids figure it out, or you can create the rules ahead of time. Okay. Here's another question. Is there such thing as an IRA trust, and what are the advantages of it? There used to be. So we used to set up a lot of IRA stretch trusts or retirement plan trusts where we would set up a specific trust just for the retirement accounts, the IRAs. So this also gets to someone else's question. Can you name a trust as a beneficiary of the IRA? We used to do it all the time because prior to the Secure Act, you could stretch the taxes, the kids or beneficiaries could stretch the taxes over their lifetime. They'd have an RMD based on their age. But like the RMD for like a grandkid might be like 1%. So 1% has to come out of that trust every year. And then if it's growing, it's say 6 to 8%, you're basically creating this annuity for the grandkids or even the kids. But unfortunately, that ended with the Secure Act of 2019. And what the Secure Act did is said that if you leave the money to anyone other than a spouse, all the taxes have to be paid within 10 years. So at this point, we're not doing any type of IRA stretch trust. Like our revocable trusts, our asset protection trust automatically build in the 10-year stretch. So it doesn't make sense to set up a separate trust just to stretch out the taxes. Because the trust that we set up already stretches out the taxes. In the past, we would do those all the time, especially with bigger IRAs. And a lot of times we want to leave them to the youngest people possible, like the grandkids, because their RMDs would be so low. So we used to do a lot of IRA stretch trusts. And that's where I'd always not laugh, but almost feel bad because we'd get like financial advisors saying, no, you should never name a trust as a beneficiary of an IRA. Well, like you're not understanding the rules. Like we've been doing that since about 2004, taking advantage of the IRA, the stretch rules, naming a trust as a beneficiary of the IRA. But unfortunately, that was the big takeaway from the Secure Act is that they ended the stretch IRA. So now, if you name basically anyone other than a spouse as a beneficiary, they can only stretch it up to 10 years. Like even if you name the kid outright. So if you name the trust, maximum 10 years if the trust set up correctly. If you name a beneficiary outright, maximum is 10 years. So yeah, we don't do any IRA stretch or IRA specific trusts. And if someone tells you to do one, they're probably just trying to sell you on the idea of like more complicated planning than it needs to be. All right, here's another one. And again, if you do have questions, feel free to put Q&A, answer that one. The Castle Trust is set up and you keep money out to handle assisted help for getting past the 5-year rule. Will that work on safety of your Castle Trust assets? So I'm thinking like, let's say we put in 500K into the Castle Trust. Okay. So what that does is it starts a 5-year race where once we make it 5 years, everything inside of the trust is protected from that $10,000 to $15,000 a month nursing home. But what happens if we need to take out, say, 5K per month to cover assisted living? So we haven't made it to the, I can't type and talk at the same time. So we haven't made it to the 5-year mark, and we haven't made it till nursing home care. Will us taking income out of the trust, will that open up the whole trust? The answer is no. Whatever we keep in the trust is protected. So if we need to pull $5,000 a month for home care or assisted living or just basic living expenses, if we take money out of the trust, that does not restart the 5-year clock. So everything remaining inside of the trust would be protected. Okay. All right. Well, looks like I answered all the questions. Thank you, everyone. I appreciate all the questions this week. We'll be back at it next week.